if somebody holds somebody at gunpoint and they want to steal their vehicle, they would say, oh my gosh, shucks, I didn't know there was a child in this car. Let me pause. But they gave nobody pause. Everybody just still continued with what they were going to do. That's a problem for the court. Right. The court is calling 2023 CR 3848, State of Texas versus Michaela Elise Johnson. Can I have parties announced for the record for the state defense?
Patrick Hancock for the defendant.
All right. And are you Ms. Johnson?
Yes, ma'am.
All right. We're here for sentencing. You entered a plea of no contest to robbery on December 4th. According to the plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison. The state is opposing your application for community supervision or deferred adjudication. They're taking certain items into consideration. All right. Did you all have a chance to review the PSI report, state?
Yes, Judge.
Defense?
I did, Your Honor.
Any objections to the PSI report, state?
No.
Defense?
No, ma'am.
All right. State, any witnesses?
No, Your Honor.
Defense, any witnesses?
Yes, Your Honor, I do. I have Miss Alicia Franklin, Michaela's mom.
All right, Ms. Franklin. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth, and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Make sure you keep your voice up so the court reporter can hear. If you can state your name for the record.
Alicia Franklin.
All right, defense.
Miss Franklin, good morning.
Good morning.
You and I have spent a lot of time together regarding Michaela, is that correct?
Correct.
And you are aware that Michaela has accepted responsibility for a robbery here in Burke County.
Correct.
And today is the day that the judge can either send her to prison or entertain her application for probation or deferred adjudication.
Correct.
Ms. Franklin, let me just ask you, how old is Michaela?
As of now, she is 18. When the case started, she was 17.
And when did she turn 18?
November 3rd.
And where is she a student at?
At Roosevelt High School.
What grade is she in?
She's a senior.
And being in Roosevelt High School, has she made future plans, applied to any universities, or done anything at this point in her senior year?
Yes, she was accepted to UTSA, and we're pending.
Excuse me. Please whisper.
Say it again, ma'am.
She was accepted to UTSA, and we're pending the application for Clark Atlanta University.
Very good. And how is she doing in school?
She's doing good. She's on my honor roll. Right now she has all A's and perfect attendance since she's been out.
And did Michaela request a letter from one of her school counselors to offer to the court today?
She did.
Ron, I tendered this to the state for their review. At some point, you'd like for you to look at that, Judge.
All right. Any objections to the court reviewing this?
No.
All right. You may continue.
Ms. Franklin, with regard to that letter, is it a positive review of how Michaela's doing at Roosevelt High School right now?
It is. Michaela's right now, she's since her release, she's at the best she's ever been. She's focused, she's serious about furthering her future for college, and she's on the right path.
I'd like to take you back to, I guess, the time around this offense. And before I do that, I want to ask you, are you a single mom?
I am.
Does Michaela have a father in her life who's active or?
He's not active, not consistently.
And does she have any siblings?
She does. She has a brother and a sister from her father.
But living in your household is
No,
just
no one, just me and Michaela.
I want to take you back to around the time of the offense. Do you remember getting a call that Michaela had been locked up for some very serious offenses?
Yes, I do.
And can you tell the court what your response was?
That she needed to sit there. I left her in there. She needed to understand what she had done and take responsibility. I left her in there for 5 months before I bonded her out, so she could understand that she didn't do anything, it wasn't something small. She needed to understand exactly what she did and what she could look forward to. She needed to know what prison or their county what jail was.
And do you think those 5 months had a significant impact in her life?
Most definitely. I know for a fact she doesn't want to go back. She definitely has a true meaning of what jail is.
And was that your goal at that time?
That's definitely was my goal, because I could have bonded her out the same day or the next day. I mean, I could have got the financial means to get her out. So it was definitely my goal for her to learn her lesson, and hopefully we don't ever have to revisit this again, which I don't think we will. I honestly think that she did learn her lesson.
Miss Franklin, let me ask you, at the time when she was arrested, were there some behavioral problems that you picked up on?
Yeah, there was, but I thought she was just being a rebellious teenager. I didn't realize she was like depressed and had low self-esteem until she had suicidal thoughts. I took her to Little Ridge, but they let her out and she did a little counseling here and there. So I thought she was just being more rebellious to herself. I honestly didn't know it was mental health issues there. But once I did know, I've gotten her help.
What mental health issues have you discovered regarding your case?
Definitely depression, low self-esteem. We've been going through exercises with the counseling sessions. And me, myself, just trying to boost her up and get on the right path to feel good about herself.
And do you think you're on a positive path right now?
Most definitely we are.
She's back living at home.
She lives at home. Our relationship is really good. She's more open. We actually have conversations about how she's feeling, and I think we're on a really good path.
And that's different than what it was before.
Most definitely. She would stay to herself more, lock herself up in her room. Just for me, what I thought was normal teenage stuff, but evidently it was a little deeper than that.
Ms. Franklin, you own a business. Would you tell the judge what you do for a living?
I do. I'm Sugar Salon, a hair salon in San Antonio.
And have you and Michaela talked about her interest in working in the salon?
Yes, but actually before this she did. She was my assistant. And to be honest, I need her back as an assistant, but she wants to be a barber and to get her through college. It'll be something for her to fall back on. And I can, I'm also an instructor, so she can get some of her hours through me.
You mentioned that she's been accepted to UTSA.
Yes, she's been accepted to UTSA, but she's also, we're pending the application for Clark Atlanta, which she preferably would want to go.
And what would be her interest in studying in college?
Business marketing.
So you left her in jail for 5 months, and now she's been on pre-trial release as a condition of her bond.
Correct.
I know we had one GPS circumstance that we had to take up with the court, but
Yes.
other than that issue that was straightened out here in the courtroom, do you think she's been compliant with all the rules?
Yes, she's been compliant, and I also make sure she's compliant. I mean, we get home on time, way before time. We don't take no shortcuts. So yeah, she's definitely compliant.
I know that today we had the opportunity, the three of us, you, me, and Michaela, to go through the pre-sentence report. You can see there are some pretty raw feelings on the part of the listed complainant.
Yes.
Can you tell me if you think, even before today, do you think Michaela recognizes just how serious this offense was and the fear that people were placed in and the after effects of that fear?
Yes, she definitely recognizes that. She's definitely voiced how remorseful she is for this. I know for Christmas we did, she wasn't able to actually go to the battered women's shelter, but she did produce a toy drive. So where she marketed it and we received a lot of toys, I think over 500, and took it back to the battered women's shelter. She definitely is remorseful, and she definitely understands that she put these people in fear, and it's not to be taken lightly.
Very good. Could you address very quickly whether you think your daughter would be a good candidate for probation or deferred adjudication in this court?
I think she would be a great candidate. I think, matter of fact, I know she has a bright future. This was something that she got herself into that I know she regrets. And I don't think that she should be sent to jail. She's done 5 months, and I understand that it's not the same as 10 years, but she definitely recognizes and has had a taste of what jail is to not do this again and not be in any more trouble and to succeed and hopefully help other juveniles and help other people who are going in that direction.
Ma'am, that's all the questions I have. The
Okay.
state has an opportunity to ask any questions they want.
Yes.
Any questions?
Were you aware that this offense occurred on February 8th of 2023?
Once I got a call from the Michaela when she was already in custody.
So you knew the date.
Yes,
And what day was that of the week? Do you remember?
I do not.
Would it surprise you that it was Wednesday?
I mean, I don't know. It is
It was a Wednesday.
yeah.
Would it surprise you that this offense occurred shortly before 1 p.m.?
The whole thing surprised me.
But I'm asking specifically about the time at which the offense occurred. Would that surprise you? Did you know that it happened?
I did know. I mean, I've known since by reading the papers, and
Where should Michaela have been?
she should have been at school.
So, do you know, or did Michaela ever talk to you about what happened during this offense?
Yes,
So you were aware that the victims in this case was a mother and her young 4-year-old son.
yes, sir.
And you had a chance to read the victim impact statement.
Yes, sir.
And did it shock you that this had a drastic effect on that family?
No, sir. I definitely understand the turpitude of the case.
So you understand what the victim's feeling when she's saying that prison would be appropriate here.
I don't think it would be appropriate for Michaela
And ma'am,
for the simple fact.
I'm going to ask if you could answer my question. Would it surprise you or does it shock you that the victim in this case is asking for prison?
No, sir.
Is it understandable?
It definitely is understandable.
And were you aware that the other two people that participated in this act, that they were both younger than you?
Yeah.
So she was the oldest one out of the group, right?
Okay. Yes.
So she should have been able to make better decisions than the other two, correct?
I don't agree with that. The other two had been in trouble. I understand, and she also was the only girl. So
And specifically her role in this act, were you aware that she was the person that drove the car that boxed in the victim and her son?
I understand that she was the driver. Yes, sir.
Specifically that boxed in the victim and her
I
son.
understand.
Nothing else to say.
All right, any other questions?
Ms. Franklin, I think I hindered it to the judge as a part of the other letter, but we did take Michaela to be evaluated by Mark Harris.
I did.
He's a licensed therapist, is that correct?
Yes.
Judge, if I didn't give you that.
Yes, you did, and I reviewed it.
Okay.
It's
very good.
attached to that.
Thank you, Judge. And you had the opportunity to look at his assessment, and that's helped you on a path of understanding her now, is that correct?
Yes, it did.
All right. Thank you.
Thank you for coming in. All right, defense, call your next witness.
Judge, that's it.
All right, did your client wish to say anything?
Judge, I think I'm going to speak for her.
All right, so I want to let the parties know that part of my question, or maybe you can address this, counsel,
Yes, ma'am.
because it says that she is minimizing her role. And it says regarding the instant offense, the defendant stated, "I have no comment at this," which I understand.
Sure. That was
But
good.
then she comes back and she does make a comment. And it says the defendant later stated, "I feel it needs to be looked into more," rather than what they are saying.
And I think we addressed that actually this morning, Judge. I think her point on that is she was charged with aggravated robbery. She did not possess, hold, or yield a gun. And so it's been kind of a process of explaining that to her. So I think that she's not minimizing her role as far as doing things with those young men. However, I think she's made a distinction that, contrary to what the state wants to put forward, is that she was not the leader of this. She was a follower in this, and she did not possess or hold a gun on anyone. So I think as to Miss Ballard's point in the PSI, maybe she could have gotten out of the car and said, "Hey, don't do that." She didn't do it. But the point of the matter is that she was in the car and not actively terrorizing these people. I make that distinction, but I also understand that if she was there, that she's a part of it.
All right, because I'm reading the PSI. I'm sorry, reading the stipulations. And the stipulations, it says that she was the one who boxed the driver in.
Well, Judge, we're here taking responsibility for the facts. So I don't think she has said that she's not guilty of this offense. I just think she has a different interpretation of her role versus those young men.
All right. All right. Anything else from the state?
I was informed by our victim advocates that the witness on Zoom was dressed. It was a brown sweater. That's what she's saying that she was wearing.
No, the person who was on Samsung, that wasn't a brown sweater. Unless I'm colorblind or something's going on, they had on no top.
Well, all right, Judge. I just wanted to make sure.
All right. Thank you. All right.
I don't want to overstep, but I do want to make a brief argument when it's time.
Yes, you may proceed.
So, Judge, when I first started representing this young lady, she was in jail. And as her mother said, usually I have to field those questions, how quickly can we get out of jail? I think Ms. Franklin took a very brave approach for a single mom, and that is that I want her to sit with it. These are serious charges. I want her to get a taste of incarceration. I want her to understand that you have to be penalized or punished for the things that you do. So 5 months passed by, and so I think that the value in that here in the courtroom today is that she has a taste of incarceration. And I think she's come out of jail, Judge, and the letter from the Roosevelt High School from Ms. Howard says she's really doing well in school. It's far from me to believe she's 17 years old when I met her and charged with such a serious crime, and she's turned 18 and she's only 3 months into her 18th year. So, Judge, it's one of those things. She's got a bright future. She's got hopefully acceptance into a school in Atlanta. She's been accepted to UTSA. Those letters, in my opinion, Judge, from Roosevelt High School, those are hard letters to get for the defense. And that's a really fine letter that supports Michaela in her application for probation. I don't want the court to think that she's minimizing this, because we've spent hours talking about the what ifs and how you can't find yourself in that situation. Her mom was bright enough through some talking that we had to get her sessions with Mark Harris, and Mr. Harris is very good through the juvenile probation and through private practice of bringing these young people in. Young people, he specializes in young offenders and working with them with this cognitive behavioral. You can't find yourself in the situation. You can't find yourself around the situation. If you do, then you need to leave. You don't need to be boxing anybody in cars. So I think this has been put square upon Michaela. I think she's done a great job out on bond. I think she's doing a great job in school right now. I can tell you that her relationship with her mother has never been better. I just really beg this court to give this young woman a chance. A conviction and being sent to prison is going to irreparably change her life. Now, I know that there's victims out there who have had their life irreparably changed too. There's nothing we can do about that. But this is a young lady who's clearly on a positive path, and we'd like for her to stay there with the court's permission.
State.
Judge, the situation here is that they specifically targeted a mother and a young child. That child's been damaged for the rest of his life. He's gone through immense trauma. And the role that Ms. Johnson played here was an important one. She boxed them in. She's the reason why they could not get away. I understand that she's made a lot of progress after the fact, but in that moment, she could have made different choices. Choices is what she's gonna have to make going forward. It's something that the state feels that prison would be appropriate here. The victims feel that prison would be appropriate here. That's what we're asking for.
Judge, I just want to, you see more of these PSIs than I do, but it looks like the juvenile offenders who I think have the more serious role in this. I can't read this correctly, but it looks like one of them had his cases dismissed, maybe placed on probation, and then one was sent to some kind of TYC placement. So I guess if I look at that, Judge, I just argue that there will be some kind of equitable position here by the court to figure out what to do with Michaela. Again, Judge, deferred adjudication on second degree felony is quite a good thing. I mean, we all know what deferred adjudication is, but sometimes it doesn't mean a do diddly damn in court. Here it makes a big difference because it gives her a chance to prove herself, and it gives the court a long leash to make sure that she's doing well. I don't know what else we could bring the court to show that she's remorseful, doing well at home, doing well on her conditions of bond. So again, we would ask that the court wisely place her on deferred adjudication. Understand that she's done 5 hard months in the Bexar County Jail. I think she spoke about her fear of the jail with Mark Harris in that letter. I think her mom made a good decision, and we're hoping that will sway the court in giving her a chance at a future without being another young Black female with a conviction on her.
Here's the court's problem, and what I think people need to look at. Sometimes punishment, and all attorneys will tell you, when we're in law school, they tell you about the purposes of sentencing. Sometimes the purpose of sentence is for rehabilitation. Sometimes it's just punishment. Sometimes it's protecting the community. There are a whole host of reasons. But your problem is sometimes when you've done something that is considered so horrendous, right? No matter the changes you've made, sometimes it's just a prison offense. There are a lot of people who do things that I'm sure if they could go back in time, they would have changed it. They would have said, I wouldn't have done it. But the boxing of someone in with your vehicle, and I read the PSI report and I read the stipulations. In the stipulations, the driver of the vehicle said, hey, my son is in the car. And that didn't give anybody pause. I would think that there are certain things that should give people pause. For example, if somebody holds somebody at gunpoint and they want to steal their vehicle, they would say, oh my gosh, shucks, I didn't know there was a child in this car. Let me pause. But they gave nobody pause. Everybody just still continued with what they were going to do. That's a problem for the court. So this is what the court...
Isn't the problem that she was, no matter what her role was, it was still going to be something that was horrendous because it's a robbery.
Yeah.
So and I'm not trying to argue with the court, but under that circumstance, then no one should be eligible for deferred adjudication.
Well, counsel, as you're aware, there are different types of robbery. And there are some robberies that don't involve a child. State?
Your Honor, so right here, one thing I did notice in the letter for the psychiatrist, something that is bothered me, I knew I'd seen it somewhere in here, is that Ms. Johnson, she said she gave them a ride but did not know their intentions, but she played a role in boxing them in. She says that she had never had or handled a gun that night. When the police lit up her car, the boys threatened her if she didn't keep going. One of the boys threatened to shoot her if she stopped. Nowhere is that brought up in the report that she had mentioned that she had said that they had threatened her. So that's just something that is
Well, I don't think it's her feeling, so it's not gonna be in a police report.
Right, but
But I can tell you that was her feeling on this. She did feel threatened by these two young juvenile offenders. But we're here today to take responsibility and not make excuses. So that's our answer to that, Judge.
All right. Is there anything else before the court makes its ruling?
No, Your Honor.
no, you're not.
All right, this is what the court is going to do. Court is going to find you guilty, taking consideration 2023 CR 3850, 2023 CR 3849, grand jury number 806632. There's to be restitution of $110 to John Bright in grand jury number 806632. Give you credit for any time served. I'm going to retain jurisdiction. Your attorney will tell you what that means, and I'm going to sentence you to 6 years in the prison. Did you review what it's entitled trial court certification with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. And Mr. Hancock, you can explain to her what that means.
I will, Judge.
All right. Do you raise your right hand for me, please? Do you solemnly swear you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you may lower your hand.
Thank you.
All right, Mr. Rojas, all of the documents that I'm going to go over with you are in English. Were those documents explained to you in Spanish?
Yes.
All right, and defense, do you speak Spanish fluently?
Yes, Your Honor, I do.
And were you able to communicate with your client in Spanish?
Yes, Your Honor.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Rojas, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it?
Yes.
All right, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor. Proceeding on the lesser included of Class B misdemeanor DWI.
Any objection?
No, Your Honor.
Did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it?
Yes.
Did you sign it in all the appropriate places?
Yes.
Did you understand the state is proceeding on the lesser included offense of driving while intoxicated first? That is a Class B misdemeanor. The range of punishment is anywhere from 0 to 180 days in the Bexar County Jail and up to a $2,000 fine. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
Do you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent.
Yes.
Did you understand by entering this plea, you were giving up those rights?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent
Yes, Your Honor.
and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Rojas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
No.
Has anyone promised you anything other than the plea?
No.
No.
Are you satisfied with the way you've been represented?
Sí.
Yes.
Are you a U.S. citizen?
No.
No.
Counsel, has your client been advised of the impact this plea will have on his immigration status?
Yes, Your Honor.
Right. Was he informed that the possibility of deportation, denial of naturalization, and the right to reentry may be revoked?
Yes, Your Honor.
Has he had ample time to speak with an immigration attorney?
It's true, Your Honor. We have an in-house counsel of immigration. On our last setting, we make sure that we do the extensive questioning regarding the immigration issues here. And we have provided that information to our client.
All right, and do you believe he understands the immigration consequences of entering a plea in this case?
Definitely, Your Honor.
Mr. Rojas, do you understand by entering this plea that it may have an impact upon your immigration status?
So,
Yes. Do you understand that you may be deported, denied reentry, and the right to naturalization?
so,
Yes. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
so,
Yes. According to the plea, your punishment is to be assessed at 180 days in the Bexar County Jail. There's a $500 fine. The state is proceeding on the lesser included offense of DWI first. Did you understand that to be the plea?
so,
Yes. Defense, is that the plea?
yes, Your Honor.
State, is that the plea?
Yes,
We have 2 years of this
All right.
profession.
Mr. Rojas, did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
So,
Yes. Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
so,
Yes. Counsel, have there been any such motions?
Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 150 hours of community service restitution, DWI intervention, VIP, ignition interlock for the full term, and 1 year driver's license suspension. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
So,
Yes. Then to the lesser included offense of DWI first, how do you plead? Guilty, not guilty, or no contest?
oh,
Guilty. State, any evidence?
contained in exhibit 1 and attachments, Your Honor.
Any objection?
no, Your Honor.
All right, state, you may be excused.
Thank you, Your Honor.
Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
So,
Yes. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
so,
Yes. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
so,
Yes. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
yes, Your Honor.
All right. Anything you wish to say on behalf of your client?
No, Your Honor, it's only a part of 4 and now 5, because is pregnant. He works here for a long time. He's aware of his residency renewal, and he's just a new labor now.
All right. The court is going to sentence you to 180 days in the Bexar County Jail, suspended. Mr. Davidson, if you can move so you won't block probation. Yeah, thank you. Court is going to sentence you to 180 days in the Bexar County Jail, suspended and probated for 2 years. There's a $500 fine that will be probated. There's going to be 150 hours of community service restitution. I'm going to order parenting classes with Compadre e Compadre. And once those are completed, the community service hours will be deemed satisfied. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. Admission interlock the full term, and the court will note that the defendant has been on admission interlock since the inception of this case. There's to be 1 year driver's license suspension. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. We're going to do 90 sober meetings in 90 days. TAP evaluation. Follow TAP evaluation recommendations. However, if TAP recommends inpatient treatment, we're going to start with outpatient treatment. And there'll be one field visit for 1 month, and then at probation's discretion. All right, probation, is there anything else he needs? All right, is there anything else you need from the court to be successful?
No.
All right, did you review the trial court?
Thank you very much.
Oh, you're welcome. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and did you sign it?
So,
Yes, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
so,
Yes.
All right, we can go off the record. If there's anything you need from the court, let probation know. If you feel as though they're not addressing it, you can always come back to me.
so,
And if ever you think that you're going somewhere and you're going to have alcohol, you're not supposed to be driving. You would have saved so much money, so much time if you would have just had someone else drive. You understand?
so,
Yes.
And I don't think Dolly Parton ever had a DWI. All right? Even when Jolene was involved. All right, have a good one.
thank you very much, Josh.
Thank you. All right, you too. Have a good one. Thank you. All right, if there's anything that you don't understand or you have a confusion about something, let me know. And there's no need to have any fear of letting me know that you don't understand something. You understand?
Yes, ma'am.
Okay.
See.
So where we left off, do you understand that if you want a jury trial, which would mean there would be 12 people sitting, hearing all of the evidence or witnesses' testimony. Do you understand?
Yes, ma'am.
All right. Do you want a jury trial?
No, ma'am.
All right. Do you understand the rights that I've talked to you about?
Yes, ma'am.
All right. Do you understand that by entering this plea bargain agreement, you are giving up those rights?
Yes, ma'am. I understand.
All right. Did you understand if the court were to grant your application for deferred adjudication, if for any reason your probation were revoked, then the court could sentence you up to 10 years in prison?
Yes, I understand.
All right. Counsel, has your client been able to provide you with any defenses?
Yes, she has, and we're pleading no contender, Your Honor.
All right. Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does, and she has assisted me.
All right. Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she was.
All right. Ms. Parra, has anyone threatened you or placed you in fear to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the bargain that you have with the state?
Yes, ma'am.
All right. According to that, there's a $1,500 fine. The state is asking that I grant your application for deferred adjudication. They're taking in consideration County Court Cause number 734347. There's going to be restitution, money you have to pay for any damages, and 734347 to the Bear County Sheriff's Office. Did you understand?
Yes, ma'am.
All right. Defense, is that the agreement?
That's our agreement. We're pleading nolo contendere, and I explained to her that $750 restitution, if she has it and she's working within those 2 years, she has to pay it.
All right. State, is that the agreement?
Yes, Your Honor.
All right. Did you review the waiver of appeal paragraph with your attorney?
That's the one where if she
Remember I signed it
sends,
twice?
yes, you signed it twice. There
Okay,
you go.
yes, ma'am.
All right. Did you understand by signing that, you will not be able to appeal this case unless there have been pretrial motions that your attorney has filed or you have filed, and that I've heard those and made a decision about those. Did you understand?
Yes, ma'am.
Have there been any such
There has
motion?
been no motions filed, Your Honor.
All right. Outside the agreement, the state is asking that you be placed on 2 years deferred adjudication, and there be 120 hours of community service restitution, which is volunteer work, and that there be a TAP evaluation, and that's to see if you have any drug issues. Did you understand?
Yes, ma'am.
All right, so that's what they're recommending. I don't have to do that. Do you understand?
Yes, ma'am.
All right. Then to the offense as charged, what plea are you entering?
No contest.
All right. State, do you have any evidence to support her plea?
Contained in Exhibit 1 and attachments, Your Honor.
No objection, Your Honor.
Did you review this document?
Yes, ma'am.
All right. And state, you may be excused.
Your Honor.
And did you understand that that document has police reports? So instead of calling witnesses, the state is just giving me things that they've said, and it's in this document. Do you understand?
Yes, ma'am.
Now you understand that you can make the state and tell the state, hey, I want you to bring somebody in, a witness or a person, to say what happened. Do you understand that?
Yes, ma'am.
All right. But because you're entering this plea bargain agreement, they're not going to bring that person. Do you understand?
Okay, thanks. Yes, ma'am.
All right.
Sorry. Yes, ma'am.
All right. No problem. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right. What is the charge in clause number 734347?
The county court case,
Yes.
that's malicious mischief, breaking squad car light.
All right.
Yeah.
Okay, because I don't have that in this police report.
Right, that's what we're gonna take into consideration, but
All
I'm
right.
gonna run to county court 5.
All right. Court will find there is sufficient evidence to find you guilty. The court is not going to find you guilty. The court will defer that because you applied for deferred adjudication. I'm going to place you on deferred adjudication.
Thank you.
All right.
Thank you.
Do you have any children?
Yes.
What are their ages?
5, 8, and 11.
All right. And who are they residing with? Where are they living?
I gave them up for adoption.
Okay.
I have requested that she apply for Haven for Hull, and I'm also need to tell the probation department to make sure that they write down the address and the directions to any meetings for probation. Is that correct?
Yes, sir.
And you will then report every time. Is that correct?
Yes.
Okay.
All right. This is what the court will do. There is to be a $1,500 fine. The court will probate that.
Thank you.
Take in consideration 734347. There's to be restitution in 73437 to the Bear County Sheriff's Office. 3 years deferred adjudication. I want a referral to felony drug court. That's to be in custody. They do have a dual diagnosis program, so they'll be able to help her with housing and
Okay,
everything else. I don't want her released and she's homeless and she has no place to go.
you understand? You're
Okay.
gonna be working with another government entity, drug unit, to find you a place to live.
Okay.
There's going to be proof of employment. There's to be proof of employment or SSI within 45 days of release. There's to be no employment as a home health care provider or with minors. And probation is, yes?
I'm sorry.
Okay, if she's not accepted into felony drug court, we'll do a TAP evaluation in custody and follow TAP recommendations.
Thank you.
And there should be no unsupervised contact with minors. Probation, I'm unsure about the 120 hours of community service restitution. I don't know if she's able to do that. If for some reason she's unable to do that due to mental health, just let the court know. So there'll be 120 hours of community supervision. There's to be a MIC evaluation. Regular reporting by Zoom or in person, and regular random UAs. And I'm going to want field visits 1 time per month until she has a case manager or is in felony drug court. And if for some reason felony drug court doesn't accept her, or if MIC says that she's not eligible for the program, then I'm going to want a referral for her to the Center for Healthcare Services.
Okay, good.
So how can help coming your way?
Probation, is there anything else she needs?
I think that's good.
All right, is there anything else you need with help from the court?
Not that I could think of at the second.
I'm sorry?
Not that I could think of at the second.
All right. Did you review this document with your attorney?
Yes.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. If you need anything or you feel there's no one to talk to, you can always come back to the court, okay?
Yes, ma'am.
All right, thank you. Court is calling 2024 CR 6101W, State of Texas versus Christopher James Miller. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Brittany Sparks for Christopher Miller. I'm sorry, I didn't hear your name. Brittany Sparks. Sparks? Yes.
All right, you entered a plea of no contest on May 16th, is that correct?
Yes, Your Honor, that's correct.
And have both parties had a chance to review the PSI?
Yes, sir.
Any objections?
No, Your Honor.
No, Your Honor.
Right. According to the plea bargaining agreement, state recommends deferred adjudication. This is to run concurrent with 2020 CR 1185C. There's to be a drug court evaluation. If not accepted, then to follow the TAP recommendations. Excuse me, do you have 2020 CR 1185C? All right, is there anything you wish to say on behalf of your client?
Yes, Judge, he is, although it says otherwise in his PSI, Your Honor, he is willing to do drug court. He did qualify, he was accepted, but they had to give his spot away, is my understanding, because the sentencing was too far out.
Mhm.
I've asked probation if there is a spot available. They said not right now, but I think they have graduation coming up and maybe a spot will be open soon. That is what he would like to do if the court will allow him to.
Okay. All right, anything from the state?
No, Your Honor, except that I think the other case, it's an MTR. I think both parties intend to sort of let that MTR expire, because it would be on the first time. It's
Okay. All right, does anyone wish to speak to length of probation?
Your Honor, our agreement with the state was for 5 years. That is what my client accepted, so.
All right, that's outside the agreement.
Yes, Judge. I mean, as far as the length, I mean, that's what we would be asking for is for 5 years, but we understand that it's your decision.
Okay. It's the 2020 CR 1185C. All right. I see the nature of that offense. And what was the length of probation on that offense? Was it 4 years? All right. All right, the court is going to sentence you to 6 years deferred adjudication. Taking consideration NIMAG number 746576. There's to be referral to felony drug court. He's to remain in custody until transfer to felony drug court. Counsel, if you reach out to felony drug court, you can see when they can accept him. If for some reason they don't have any room for him in the foreseeable future, just let the court know and the court will consider a different placement. But for now, he's to remain in custody until accepted into felony drug court. There's to be proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. There's to be regular random UAs. There's to be 200 hours of community service restitution. The court will not waive any of those hours. You're going to have to do those hours. You understand?
Yes, ma'am.
Oh, thank you. And it says in here that the guilt was minimized. Why is it saying that?
I'm not sure, Your Honor. In the
PSI? Yes. It says that he minimized guilt.
Yes, Judge, there was, the Nightmare case was a possession charge. Mr. Miller and I have spoken at length, because he had a difficult time accepting responsibility for the possession charge. We have spoken about him accepting the responsibility for this tampering with evidence. So I think since he has spoken to the judge, he has come to the realization of where we are with this case.
And what are you planning on doing with the rest of your life?
I mean, I've worked out there. I mean, I continue to have jobs, and I mean, I just need a steady balance. That's why I want to get into the felony drug court.
Do you have any children?
I do have a daughter.
And what's her age?
She just turned 10. I just missed her birthday because of all this.
Okay. I'm sorry, Mr. What?
I missed her birthday because of all this.
All right. Well, I mean, you missed her birthday for your own actions.
Right.
All right. There's to be no unsupervised contact with minors. I'm going to order parenting classes. There's to be field visits 1 time per month until further notice. And probation, if for some reason he is not accepted into felony drug court. Yeah. If for some reason, with regards to felony drug court, he's going to remain in custody until they accept him. So he's to remain there. If it's taking a long time, then probation, you can let me know, or his counsel can let me know, and then I'll decide to do something else. But he's not to be released until he's in felony drug court.
Okay, finish it.
All right. And probation, is there anything else he needs?
No, Your Honor.
All right. Is there anything else you need from the court to be successful?
No.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, everyone, when we're on the record, when we're on the record, there's a sign. Do y'all see that sign? All right, thank you. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you, and I hope those burns heal. What were you doing in the kitchen?
I was cooking.
What were you cooking?
Dinner.
I mean, what's the meal?
It was just oatmeal, honestly.
Yeah, I had a feeling. Bear County Jail, probably oatmeal.
I have a slight issue with that though.
Mm-hmm.
Due to the burns and infection and getting health care and seeing a doctor and going to do that. I mean, I've been waiting to go and waiting for this PSI and waiting in the drug court for the last 30 days. I know you said I have to do it in custody.
Yes.
I mean, even with monitor or anything like that. So I'm trying to go and.
Because here's the thing. You have a drug problem. You have a major drug problem. The fact that you're on probation, the state made an offer with you. Even though you're on probation for another case, they made an offer for probation on this case.
Yes, ma'am.
So people always want the sun, the moon, the stars. And then when they're at the very beginning, when they're looking at prison time, it's always like, I'll do anything.
Well, I mean, it was just because just because of the sentencing wise, I was already accepted in the drug court. I missed it.
Yeah. I mean, I could send you to prison and they'll give you, I think they have better medical care at the prison if you want.
It's not what I want.
Okay.
Yeah. So and I'm not trying to argue with the court, but under that circumstance, then no one should be eligible. And just like that, the reality of the legal system sets in. A mother tried her absolute best to fix her daughter's path with 5 months of tough love, but the law cares about the victims left behind. Justice does not always move fast, but it always demands true accountability.